rise. The Court of Appeal in for the 6th District of the State of Florida is now in session. The Honorable Perian Wozniak, Judge, presiding. All persons having business before the court draw near to the attention and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to a session of the 6th District Court of Appeal here down in Naples. I would like to thank our host, the 20th Judicial Circuit, and Chief Judge Frank Porter for hosting us today. Just a reminder that we may be recorded today, so we may be broadcast on YouTube. We're going to go ahead with the first case, but first off, let me introduce my colleagues. To my left and your right is Judge Roger Ganem, and to my right and your left is Judge Joshua Mize. All right, let's move on with the first case. It is 23-4106, Elise Samuel Caballero Quinones versus Kyle T. Wilder et al. Good morning.
My name is Justin Blakely. I represent the appellant. If I could reserve 2 minutes of my time for rebuttal.
2 minutes, okay. Let me adjust that. Okay, and you may begin.
Great. All right, so this was a car crash case, and the facts are a little bit important. So liability was hotly contested. The facts were that the sheriff vehicle, or the defendants in this case, sheriff vehicle was going through an intersection, and as it went through an intersection, it collided with another car, and they spun out and collided with my client's car, right? So the sheriff's position at the trial was that they weren't at fault for the crash. There was nothing they could do to prevent it. Our position was that they drove negligently, and that there were things they could have done to prevent it. They could have driven more safely through the intersection. So,
Counsel, I know the motion in limine was litigated at length. Is there a transcript of the hearing, the motion in limine hearing that was held before the trial?
no. So the only record of the arguments are the trial transcript records.
Is there an Applegate issue because of that?
That wasn't raised below. I thought that,
Applegate issues can't be raised below.
well, I
It's an
mean,
appellate issue.
right? It's our position that the full arguments on that motion were addressed at the trial again. So that there's no issue of a lack of record before the court.
But there's no way that we know that, right? And the judge's memory didn't seem super clear because I guess it had been a while ago about the reasoning for why the judge ruled the way that the judge did.
In the transcript, he said he found his notes, and that he remembered how he ruled per his notes, and also, motions in limine, of course, can be relitigated in the trial, which is what this one was. And so it's our position that because it was relitigated, and because there was a full record down below and now before this court, that the court has a record on which to make a decision.
Do those rulings stand alone, or is it one ruling that happened in multiple places, or is it independent rulings that we would look at each independently in terms of evaluating whether we have a sufficient record to?
One ruling that happened in multiple places. So there was the issue, because we brought up the issue again to the court, as we thought that the evidence in court merited it, the court addressed again all the arguments every time we brought it up in front of the court. So it's just our position that because it's a motion in limine, because those are evidence dependent, because those can be reheard during the trial, that there's a record for this court to make a decision. And
if you're rehearing it, doesn't that imply it's a new determination as opposed to a continuation of the prior ruling? Because if you're still doing the prior ruling, you're not rehearing the prior ruling. If you're saying they're one continuous ruling and that the trial ruling was a rehearing of the prior ruling, those are irreconcilable answers. You can only have a rehearing of something that's been completed and is now being done over independently.
Yes, but Yes, but in the motion in limine context, the the context for the court to evaluate the issues in a motion to limine a change as it comes up in the trial. So, again, it's our position. This isn't like where there was an evidentiary hearing and the court doesn't have record of an evidentiary
No, but
hearing.
so that's a good point. So the context of the trial is different. You now have more information. Doesn't that indicate it's a separate evaluation of the issue, separate from the ruling on the motion in limine?
I mean, separate, but based on the same record, because it was based on the deposition transcript that was entered into evidence and that is part of the record before this court. So, I guess he was making another determination, but the basis for his determination didn't change because it was all based on the deposition transcript, which is the only.
I'm trying to figure out whether we have a complete record for the ruling that you want us to examine.
Yes, it's
Right.
yeah.
We don't have a complete record of the limine because nobody got a court order, right?
Right.
The rulings at trial, we do have a complete record. And so what I'm trying to figure out is the ruling that you want us to look at, is there a complete record of it?
Yes, because it was completely made during the trial, and it wasn't based upon anything that wasn't in the trial transcript and is not before the court.
In the trial ruling, did the trial judge indicate he was incorporating a prior ruling in any way? I know the trial judge recalled the prior ruling, but was any of it incorporation by reference or anything to the prior ruling, or did the trial judge make a new ruling?
He made a new ruling. So yes, he didn't say he was incorporating anything he heard before. He said that he heard some arguments and he made a ruling based upon the arguments that happened in front of him in the trial. And those arguments, were that this is an admission, an admission by the defense that this accident was preventable. And because it was an admission that this was preventable, we thought that the jury should be able to consider that when evaluating the defense's new position that it was not preventable.
I'm struggling with relevancy. How does relevancy play into an admission? If there is an admission, does it just automatically come in whether or not it's relevant? Or do you still look at relevancy?
You still have to look at relevancy. And the relevancy in this case was that the issue was fault, and the admission arguably is an admission of fault. And so that's what made it relevant.
Under a completely different standard after the fact, a disciplinary proceeding.
That's how the defense wanted to put that admission in context. But that's a weight issue for the jury, not a relevance issue as to whether their statement that the accident was preventable was relevant.
Whether it's preventable, that wouldn't establish negligence, but it could be a factor in assessing whether there was negligence?
Yes, yeah. And we thought at the trial court level, we thought that the Lee case was especially on point. That's a Florida Supreme Court case. In Lee, there was an investigation after the fact by an investigator into some alleged negligence at a home for the disabled. And the Florida Supreme Court found that after the fact investigation, which found negligence, which found neglect on the part of the corporation there, was admissible as an admission. So we thought Lee, in its after the fact investigation, was entirely on point with this.
What was that admission deposition testimony in the Lee case? What was the form of the admission?
The investigator testified in the trial. So he testified in the trial as to his conclusions. He prepared a report before trial, but at the trial in Lee, he testified as well.
I guess, so normally you need an admission against interest as a hearsay exception, right?
Yes.
And if the person is in court testifying, unless they're testifying to someone else's out-of-court statement, that's not hearsay, right? That's just testimony. You don't need an exception to get that in.
Yes.
So how is it, break that down for me in Lee, why you needed an admission against interest. You don't need an admission against interest for somebody to get up on stand and say, I evaluated myself or my team and we determined there was fault. There's no hearsay there that you need to have an exception to.
So the investigator in Lee didn't witness what happened. So he took statements from lots of people, employees of the company. And so his conclusions were based upon what other people said.
Okay.
Just like in this case, the the sheriff who made the statements wasn't actually at the scene, and so his conclusions were based upon what other people may have said to him.
Okay, so because this was deposition testimony of a party,
Yes,
right? That can come in typically without a hearsay exception. Now, obviously, if he's testifying to hearsay, right, just like any other testimony, that would be subject to hearsay. But just his testimony is not hearsay because it was deposition testimony of a party, which you could just use as testimony at trial. So statements that came from someone else of, hey, this officer said this, assuming they're offered for the truth of the matter asserted, that would be hearsay and you need an exception. His conclusion of the sheriff's office made the determination that Deputy Harvey could have avoided this accident, that's not hearsay, is it?
no, it's not hearsay either, as we argue, because it's an admission or because it's a statement.
Well, hold on. It's an admission is a hearsay exception,
Yes.
right? And that's what you need to get in hearsay that would otherwise be excluded. If it's not hearsay, you don't need an exception. And it doesn't matter if it's an admission. You can just testify to it because it's not hearsay.
That's true. Then the issue is whether his testimony was relevant, and we thought it was relevant for the reasons sort of I've discussed before. Because of
I guess what I'm saying is there was a lot of talk in the briefs about whether this was an admission against interest, and I get that for specific statements he made of, hey, this officer said this to me, right? That would be hearsay. But everything else in his testimony, just what conclusions did the sheriff's office reach, that is deposition testimony of a party. That comes in, that's not hearsay. Deposition testimony of a party can be used just like live testimony. That's what 1.330 says.
Yep.
So there's no hearsay exception required or relevant to that coming in, right?
Agreed.
So the hearsay would only be limited to specific statements he testified to of other people.
Right.
The Lee court concluded that both the investigator's statements may come in as statements against interest, but also any statements made to that investigator by employees involved in the investigation. And the court used the term may. It didn't say it necessarily would come in, but it said it may come in. Sure. So under Lee, would it be your position that both the Lieutenant Allaire's conclusions as the person who investigated this post-accident, that his conclusions could come in, but also anything that Deputy Harvey said to him in the course of that investigation, would that also come in under Lee, under that statement against interest?
Yes, that'd be our position. Yes.
So help us, a lot has been made of the privilege for accident reports and also the exclusion of citations. So this is a different situation where the police is also the employer. And so do those, the privilege for accident reports and the inadmissibility of citations, does that have anything to do with what you're arguing? In other words, can we separate those out and say, yes, the accident report and the citation given, those stand over here as inadmissible, but we're talking about something different, just an employer's investigation. Employer happens to be the police, but it doesn't have anything to do with those other items?
Right, that's correct. So accident report statements are compelled statements made to complete the traffic crash report. There's this, the investigation of Deputy Allaire wasn't compelled statements made to complete a crash report. So the crash report privilege doesn't apply. And also, the Sacred Heart case was relevant, and you brought it up in terms of the citation. There's no evidence, there's no record that the conclusions of Deputy Allaire were based on the statement, but were based on the citation. And also, the jury would have received those statements
Does
without.
it matter whether they were based on the statement? On a citation? I mean, the statute says citations are not admissible. Right? That's what the legislature chose to do. Such citations shall not be admissible evidence in any trial. It doesn't say investigations based on a citation or that led to a citation or that contain evidence of a citation. It says citations. So the fact that the investigation was based on or involved the citation seems just wholly outside the statute.
I agree it's outside the statute, but the Sacred Heart case did sort of make that reference. And so, the court would have to determine, I guess, if you thought Allaire was statements were based entirely on the citation, you'd have to determine if you agree with the Sacred Heart case, which is another DCA, or not. So but I agree with you. I agree with that statement that because nobody tried to introduce a citation, then it doesn't really matter if it's based on the citation or not.
And none of the testimony, was there any of the testimony of Lieutenant Allaire that was sought to be admitted where he said, a citation was entered?
No, sir.
Can you address 403? When I'm reading the transcript, I'm wondering what the trial court, like, I guess the spirit of the trial court's oral ruling. Was it under a 401 analysis, a 403 analysis? Was the trial judge concerned about confusion of the issues in the standard of proof for the jury?
So the way it seemed to me when I was there, and the way that it seems to me from the record, is that he thought that it was a subsequent remedial measure. And then he seemed to really focus on that. And then he focused on the accident report privilege. So I don't think he made a 403 analysis. I think he made legal analysis in that he thought it was a remedial measure and he thought it was protected by the accident report privilege.
And did he also find that it lacked relevance?
So I don't think the record says that, and I don't recall that from the record. I specifically, the record says he made these legal conclusions.
One of those legal conclusions relevance?
No, Judge, I don't believe that's in the record.
It was argued, though.
Yes, it was argued by the defense at the trial, yes.
And it could have been argued at the hearing, but we don't know.
There's no record of the hearing. Yep, that's true. But there is, to go again to that point, there is a record of the judge's rulings at the trial.
Counsel, this might go to the relevance issue. In looking at the deposition transcript for Lieutenant O'Leary, this is on, I guess it's page 266 of the record, but the question you posed is, okay, and that's because the sheriff's office found that Deputy Harvey failed to act with due care when operating his vehicle during the crash, correct? The witness, right. So is that statement by Lieutenant O'Leary, is that statement that Deputy Harvey failed to use due care, is that equivalent to the legal standard for negligence? In other words, are those the same thing, or is there something else in the Sheriff's Department's investigation, and when they conclude no due care, as compared to just the legal standard for negligence?
So that's what the defense argued below. They said, the standards are different. Our position is that that's a jury question. The jury can evaluate that statement and say, well, we think the sheriff was admitting fault, or we think they weren't admitting fault based on that statement. The relevance is that a jury could look at that statement and say, well, the sheriff thought this was preventable, and now they're saying their deputy couldn't have done anything, and those are inconsistent positions. And so that's why we thought it was relevant.
How would the sheriff's office have gotten that question before the jury? Would it have been, like, for example, at trial, up to the sheriff's office to put Lieutenant O'Leary on the stand and say, explain what you meant by due care, in that post-accident investigation, and then argue that was different from the legal standard for negligence? Or is that your burden to show affirmatively that this investigation standard that Lieutenant O'Leary used is the same as the legal standard for negligence, or to point out the differences?
So I think that the explanation of this statement should have been on the sheriff's office, because they were the ones who didn't want the jury to credit that statement. We weren't arguing that there was some legal determination that the jury had to follow. We were arguing that the defendant's statement about fault was relevant for their consideration because they were contesting fault in the trial.
Also, whether someone was at fault or didn't exercise due care is their legal conclusion. Their conclusion that he could have avoided the accident. That is a factual issue that could apply to various legal standards, right?
Yes, absolutely.
How do we write, I have a concern, if we write an opinion in your favor, I think that these subsequent investigations that the sheriff's office is doing is probably a good thing to figure out what's going on, maybe see if the sheriff needs to be disciplined. How do we write an opinion that's going to cover this entire district, be the law of this district, without kind of discouraging those types of investigations and candor that goes into them and all of that, if there's a concern that this is going to be introduced into evidence in every negligence case?
Certainly the two sides of it can be separated. So any punishment, or training that the sheriff's office gives a deputy, that's not admissible, that can be excluded. So the opinion could talk about the two different aspects of it, whereas, factual conclusions or factual statements about what happened are admissible, but training, remedial measures, discipline are not admissible.
So, your position as a 403 analysis didn't happen, correct?
Correct.
Okay. So if we were to reverse, saying that the judge was wrong to exclude the evidence, the testimony under subsequent remedial measures, accident crash report, and traffic citation, That would mean when it goes back down, a 403 analysis is still able to be done, correct?
Yes.
Okay.
Yeah.
So you could go down and judge could still exclude it on 403 and this could still be excluded, correct?
We think that would be an abuse of discretion, but yes, yes,
Well, that would depend on what was presented at that trial, right?
yes.
So there's no way for us to know now whether it'd be an abuse of discretion, or for you to know, right?
Sure.
Because you don't know what trial counsel, if that'll be you or somebody else. But my point is, you're not asking us for a ruling that this comes in.
No.
You're asking us for a ruling that it was excluded improperly on certain grounds, and grounds that not ruled on are fair game at the next trial.
Yes.
Okay, you're into rebuttal time.
Great, thank you.
May it please the court, Barbara Davis on behalf of the sheriff in his official capacity. I think the last thing you were addressing to me is the core of this case. And unfortunately, I think you may be correct that the record isn't complete on the issue of the 403 analysis. The 403 analysis, although the substantive substantive remedial measures is a key issue, and I believe is in our favor for excluding this evidence. In the end, if you take all of the parts and you do the analysis, it's a bit of a weighing situation where...
It seemed that you asked us in your brief to affirm under tipsy coachman based on 403, correct?
I did, yes. I think it,
So in order
because
for it to be tipsy coachman, that means it's something the trial court did not do, correct?
I believe you're correct, yes.
So you've accepted, you've conceded in this action, in this appeal, the trial judge did not rule based on 403 because if he did, tipsy coachman wouldn't be the right argument, right?
Well, I've conceded that there isn't evidence of that in the record because the only evidence is that in the motion in limine, that argument was made. And in the memo in opposition to the motion for a new trial, that argument was made. But in both cases, we never had an order on the motion in limine. They weren't able to find it, and there's no record of there's no transcript of the hearing. And then there's, on the order for the new motion for new trial, there was just strictly an order denying it. So we don't know what the basis was for that in that case.
Can you address what your opposing counsel said about relevance in any of the places the trial judge ruled? At any of the various points in rulings, did he say that this lacks relevance?
I don't know that he put it in those terms. I don't recall that it being in those terms. I mostly recall that he discussed the substantive remedial measures and then also the citation issue. And in my mind, the subsequent remedial issues and measures is an issue that the appellant has kind of divided into the why versus the what. Like, why did they take these measures versus what the measures were? And I don't think you can divorce those two issues.
Let me ask you a question about that. Suppose that in this case, the sheriff's office had done a post-accident investigation and concluded that Deputy Harvey did nothing wrong whatsoever, followed the policies, did everything by the book, it was just unavoidable. Would evidence of that investigation be evidence of a subsequent remedial measure? Because to me, a measure is something that's done to address the situation or to fix it or to make it better next time. But simply investigating to ask the question, was something done wrong? How is that a measure under the rule excluding subsequent remedial measures?
I think that, again, I mean, if I were on the other side of that issue, certainly I would say that it still shouldn't come in because in that case, they're looking at their policies and they've found that to be honest, in most cases, their position is if the accident happened, we don't really care how it happened. There's something that needs to be done. We need more training. We need discipline. just because it happened, just to try to do everything they can to protect the public interest. And I think particularly when you have a specific action taken, there's always going to be an analysis of why is this necessary? If it isn't
Counsel,
broken.
Yeah, but there could be a lot of things. There could be a budget for the subsequent remedial measures. There could be an analysis that leads to it. We're not here deciding like what does it make sense to exclude or what we think is a good policy. There's a statute on this.
Right.
The legislature looks at all the things that go into this, and it said evidence of measures are admissible, right? That's what the statute says. It does not say investigations that led to measures or that were used to determine whether measures were put in place. Where would be the textual basis in the statute for excluding anything other than the actual measures taken?
I think that it is evidence of measures taken. When you have made the analysis that measures are necessary, then that is evidence of the measures themselves.
Is anything they tried to put in saying this analysis led to measures, that based on this investigation, we disciplined him?
In the
In the testimony that they wanted to admit.
Lieutenant.
Is any part of the testimony they tried to admit include something where Lieutenant Allaire says, based on this investigation, we took measures, including discipline or training?
He does talk about the fact that they did the investigation.
That's not my question.
Yeah.
Specific question, I want an answer.
Okay.
Is any of the testimony they tried to admit included Lieutenant Allaire saying, based on this investigation, we disciplined him or took some other measure?
I don't recall if he said that specifically in his
He didn't.
testimony.
So how can the investigation, without any mention of measures whatsoever to the jury, be evidence of measures? Is the answer that it can't?
I respectfully disagree that I believe that it's all part of the whole process. It's part of the process that you go through in taking any remedial measures, and to allow that to be separated from the measures itself is allowing what you're going to use as an exception for impeachment purposes. And as 11th Circuit has warned, if you allow that to be used, you're gonna engulf the whole rule.
Right? So the exception for impeachment is a way to get in subsequent remedial measures, evidence of measures.
Mm-hmm.
If it's not subsequent remedial measures, you don't need to get to an exception because it's not barred in the first place because it's not a subsequent remedial measure. And so what I'm asking you is, how can testimony which in no way mentioned measures of any kind be evidence of subsequent remedial measures?
You may be right about that. I do think, though, that the analysis then moves to where we have a real issue in the lack of the record, is that is something that you would weigh on the side of prejudice versus probative
all right.
value.
So subsequent remedial measures, I'm taking that as a concession. It was not properly excluded into that because you just told me it's not evidence of measures, but you're saying 403.
Yes.
Counsel, I want to ask about the record issue, because when I look at the parts of the transcript where the issue was raised again, it was raised several times, and the first time, and this is on page 910 of the record, trial counsel says, "Judge, 3 reasons why you granted our motion in limine to preclude this very thing. 1, everything they want to put in is hearsay after the fact. 2, it was a review process for training. It has substantive remedial action, which we all know how that works. And 3, the relevance." Given that we don't have a transcript from the first motion in limine hearing, why can't we rely on trial counsel's statements to the judge? These are the 3 bases you made your ruling on, and those 3 bases don't include 403. And we add to that as sort of as a bookend your statement in the brief that the trial court did not specifically rule on the basis of 403. Can't we rely on those things and be confident that 403 was not part of the trial court's original ruling?
I don't think you can rely on that. I mean, I think you can rule on that basis if you're willing to say, just strictly on what the record is, and we don't know what happened with the 403 analysis.
Well, hold on, his question is, can't we say we do know because you made a concession? Like, if you say in your brief this didn't happen, we're entitled to rely on statements in your brief, correct?
Yes.
Okay. And you say in your brief, the trial judge did not make a 403, did not rule based on 403, correct?
I guess maybe I misstated. I think what I meant was that in the record, there's no statement of what his position was on 403.
But isn't, trial counsel for the sheriff stating affirmatively to the court, these are the three bases for your ruling, can't we rely on that also as a concession? I mean, do we need to look past that?
No, I think you can rely on that. I think then we're just going to get to the issue that you brought up earlier, that this will probably end up back here once it goes back down and we fully, develop the record on the issue of the 403 analysis, and then it will come back here on that issue. So, I mean, under the 403 analysis, I think it is weighed so heavily, I believe, for all of the reasons of the subsequent remedial measures, even if it doesn't fit technically into that rule, and also on the citation, the kind of the end around of getting the evidence of the citation, because although he didn't mention citation, he several times testified that there was a failure to yield the right-of-way, which was what the citation was.
Counsel, two things. Number one, in your brief, what you said is, you clearly made the concession. You say the trial court did not specifically base its decision on the Rule 303, on the Rule 403 standard. Appellee is not suggesting that the trial court reached the right result for the wrong reason, but implying that 403 was not the basis. So it doesn't seem like you were saying in your brief that it's not specifically in the record where he made a ruling based on 403. You seem to clearly say in your brief he did not base his ruling on 403.
Right. As far as the record, we have no evidence that he did. There's no evidence of that.
So to clarify, you were talking about going back down to the trial court for a 403 analysis. Can we not tipsy coachman this and affirm it on 403, given what we have?
I believe that you can, because I believe that the record was developed sufficiently to be able to do that. Both taking all of the analysis on the subsequent remedial measures, the analysis on the use of the evidence of a citation, although that word wasn't used, even though it may not technically fit into that statute.
Counsel, doesn't that presuppose that talking about an analogy to subsequent remedial measures, that we can just assume that that's an analysis of prejudice? So it's not like the legislature said in the statute, subsequent remedial measures or citations are inadmissible because they're prejudicial. That's just an assumption that they relate to prejudice. There could be other policy reasons the legislature did that, such as encouraging people to take subsequent remedial measures.
Absolutely.
Right? It's not that they're prejudicial. We just don't want people to have fear. Right? Talk about the accident report. That could be to encourage candor in accident reports. So to say, well, he analogized this evidence, even though it didn't fit within the statute, he analogized it to the statute. We should find that's a prejudice finding, even though he didn't say it, just assumes that analogizing something, that those statutes are based on prejudice, and that we can kind of extrapolate that as a prejudice finding. When the statutes don't mention prejudice, we have no idea why the legislature did it. And the trial judge didn't say, I find they're prejudicial in the same way as those things. So I found they're like those things, but what's the leap there that gets you to that's a prejudice finding?
I think if you are using the tipsy coachman doctrine to make that analysis, I think the prejudice is that you are prejudicing the litigant for taking these measures, and by subjecting the
403 analysis is not prejudicing a litigant and whether they want to take the measures. I mean, that's very far off from what 403 is. 403 is prejudice in the litigation, like trial prejudice. right? 403 doesn't consider out-of-court prejudice of this hurts them outside the litigation, does it?
I'm not sure that the case law is definitive on what all the prejudice
Do you think the case law is
entails.
open as to whether prejudice for 403 purposes considers prejudice completely outside and unrelated to the trial and the litigation?
I'm quite frankly not sure how far it extends, but I do think even in the litigation, there was prejudice because of and again, the record is probably not completely developed on this issue because at the motion in limine, it was ruled inadmissible. And so there was never the live testimony of the lieutenant, but there's prejudice in that in the deposition transcript even, he indicated that the standard is preventable and that that standard is a different standard than what the...
That's certainly an argument on 403, and I get it. The trial court didn't make that 403, you've conceded, and you're saying we should. When a trial judge makes a 403 determination, so say like just trial judge, I'm excluding this under 403, right? I find the prejudice outweighs the probative value. We review that for abuse of discretion, correct?
Mm-hmm. Yes.
So that means the trial judge exercises his discretion based on things in the trial that we don't see. And it could be the case that the trial judge could have gone either way, and that either way would have not been an abuse of discretion, correct?
I wouldn't agree with that. I would say that...
You think abuse of discretion always means there's only one right result?
No.
Yeah, I'm saying in a hypothetical case, not this
Oh,
case.
Okay.
In a hypothetical case,
Yes.
there could be instances in which it was close enough that a trial judge wouldn't have abused his discretion either way he went.
Yes,
right?
yes.
And that's why we review it for abuse of discretion is because there's some discretion involved, right?
Mhm.
Okay. Do you know of any other, how can we, assuming it's discretionary, now I know you're saying the evidence is, all points one way in this case, right? For a discretionary decision to tipsy coachman it, we can certainly think, would there have been sufficient evidence or sufficient circumstances for the trial court for one result or the other to be within the trial court's discretion? I grant you that. How can we know whether the trial judge, as a general rule, not just specific to this case, actually would have exercised his discretion that way?
Based on this record, we don't know, and we certainly cannot, surmise. I mean, I think based on his rulings, on his ruling, you can assume that he might go that way.
We can guess.
But you would be making an assumption, yes.
We would be assuming he would have exercised his discretion one way or the other.
Right,
There's no way we can know whether he actually would have done that, correct?
that's correct,
And normally in 403, trial judges exercise the discretion and then we review it, correct?
yes.
What would have to be developed back in the trial court in order to make a 403 determination that we couldn't make now?
I think particularly it would have to be developed about how these review boards operate, what evidence they're looking at, what their standard is. I mean,
So are you conceding that we can't use tipsy coachman on 403?
No. I mean, I was thinking more in terms of just developing the record for the purpose of like the citation issue. And I wasn't thinking so much on the development of the, but I'm sorry.
Is there any other instance where appellate courts exercise direct discretion over evidence, over admission of evidence, as opposed to reviewing discretion? Is that a thing that appellate courts ever do ever?
Yeah, I'm not aware of that.
Is that something as far as you know, appellate courts don't do?
I mean, I believe that they use the tipsy coachman as long as the facts have been developed.
I think that was my question. What facts still need to be developed for the trial court to make that determination that we could not make at this point based on the facts that we have before us.
Well, I mean, I believe that the trial court could have made the determination based on the record that was there. But I think that, in hindsight, we would do things, things would be done differently. And especially if we were concerned about, ending up in this same situation. Obviously, knowing what we know now, we would change that. But even on the record as it was, I think there was enough in the deposition transcript to show that this was a different standard, and that they were relying on the statement of the deputy in this case, the accident. They were relying on the report of the investigating officer. I think that's indicated in the transcript. And those are things, that information normally would not, I mean, this is such a unique situation since they employ the deputy, and also because of the fact that you have the same people who are deciding the discipline and the additional training and that sort of thing. Those same people are the people who investigate accidents. And they're the ones who, their decision about who to ticket, who's at fault, in their opinion, would normally never come into a trial. Yet, because of this review board, and because of their efforts to improve upon their training and their policies and using punishment as a deterrent, because of all those that affect the broader public interest, they, there's, the argument is that those should come in. And really,
Isn't it also just because they're a party? Like when some third party says, I think somebody did something wrong, assuming they're not an expert, that doesn't come in. When a party says, I screwed up, that always comes in every case, always, right?
not in every case.
Well,
And
unless there's some exception, right, unless there's some reason not to, but
Yes.
generally, when a party testifies in a deposition or at trial, because this was a party's deposition, I screwed up. Isn't that generally admissible?
I think generally, but again, in this case, it shouldn't because of the detriment that you would do to these review boards all over the state, and the chilling effect that you would have on what is a great public, what's a public policy of, safety. And I think that gets again into the weighing perhaps of the 403 analysis. But
The legislature has given us several statutes where they say, we don't want this coming in, right? Accident crash reports, subsequent remedial measures. Is there any statute where the legislature said, hey, if a sheriff's office investigates one of its crashes, nothing about that investigation comes in? Is that one of the things the legislature has chose to exclude by statute?
not that I'm aware of, no statute on that.
Okay, your time is up. Thank you.
Thank you.
Okay, can I ask my question that I asked your opposing counsel about what factually still needs to be developed in the trial court to make a 403 analysis?
I don't think there is anything that needs to be developed. The trial court didn't conduct one, but in terms of the record, the trial court could have chosen to conduct one and did.
So you would, if you went back down, you would just be re-arguing the same facts that are already in the record?
Yes.
Okay.
And then just in rebuttal, I think they've conceded on appeal that the record was developed sufficiently. So I think based on arguments of counsel and the lack of argument in their brief that the record wasn't developed sufficiently, that issue arguably is taken care of. And then finally, they argued a lot of policy arguments. It's our position that the court should look first to the law, and then policy should be a lesser argument. But in terms of what the sheriff's offices could do, if they wanted to have every deputy who ever got in an accident get training, they could, and that wouldn't be admissible. So it wouldn't affect training.
Counsel, if I could, if you do go back down below and have a 403 hearing, and the sheriff's office puts on more evidence about their process and things like that. Do I take your answer to be you still wouldn't put on any more evidence, or would you respond to whatever they put on?
It would depend what they put on, but we thought our position was the discrete statements we wanted to be in, that with those discrete statements, the record was developed enough because it was inconsistent with their position at trial.
Thank you.
Thank you, counsel. Okay, we're going to move on to the next one, but give you a couple minutes to switch cases.
Your Honor, can I ask questions? Are there students that are in danger?
Oh, I don't think that there are. Do you all know if there are any? No, so I think you're free to leave. Thank you very much for making the trip.
Thank you for asking, though. That was very
Yes,
considerate.
yes, thank you. Okay, the next case is 23-3665 Pedro L. Colon versus Jeffrey M. Bird individually and on behalf of his minor child, GL. How much time would you like for rebuttal?
Your Honor, I'm going to try and save about 5 minutes.
Okay, thank you. And you may begin.
May it please the court, I'm Peter Webster with Carlton Fields, and I am here on behalf of the appellant, Pedro Colon. We have 4 issues, as the court is aware. I intend to address them in the order that they're presented in the briefing, understanding that we will almost certainly not get through all 4, and recognizing that we will submit any of the issues we don't get to today on the briefing. So the first issue is that the trial court erroneously denied the motion to disqualify Bird as trial counsel. That issue is controlled by the plain language of Rule 4-3.7a.
Counsel, if we were to reverse on that issue, do we have any of the other issues that survive, or do they go away as well?
We would certainly like you to address the second issue as well, the discovery issue. Issues 3 and 4 would go away.
Okay.
So on the first issue, the disqualification issue, the issue is controlled by the clear language of Rule 4-3.7a of the rules regulating the Florida bar. And that rule says that with 3 exceptions, none of which is applicable here, a lawyer shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness on behalf of the client. Notwithstanding repeated objections and motions for mistrial, Bird was allowed to testify. In fact, he was the final witness for the plaintiffs. He was allowed to testify at length about contested matters central to the case, including GL's condition before and after the accident, and her injuries, and to matters related to the accident itself. He also testified several times incorrectly about legal matters, including that the medical bills were his obligation under the law, even though he was neither GL's natural nor adoptive father.
Mr. Webster, as I read the record, my understanding is that the trial court denied disqualification based entirely on a legal premise that Mr. Bird had the right to represent himself, and even as the parent or next friend of his minor daughter, that he also had that right. So he was essentially pro se in both capacities. I don't find a Florida appellate decision directly addressing this question, but there are several federal appellate decisions, and I'll just read an example from one. the 11th Circuit in Whitehurst v. Walmart, it's a 2008 case. The court said a non-lawyer parent has no right to represent a child in an action in the child's name. Is that the rule that you're asking us to state in an opinion reversing, that Mr. Byrd may have been able to represent himself pro se and has a right to do that as the parent of a minor party, that right doesn't carry over into that capacity?
I don't think that's the only rule we would like you to set forth. Our first argument is that because of the factual situation here, Mr. Byrd shouldn't have even been allowed to represent himself in this trial because the two representations were inextricably connected. It's also pretty clear that this was a ploy to allow Mr. Byrd to testify in a closing argument manner, and it's perfectly obvious if you read his direct testimony. He wasn't responding to questions. He was providing speeches in response to every question. But it's clear, bottom line here, no matter how you look at this, it's clear that the real party in interest in this case was GL. This case is really all about GL and her injuries. Mr. Byrd, as a stepfather, in fact, had no legal claim for medical bills.
Counsel, I know you raised the fact that he couldn't represent as a parent, right, whether he was a parent or not. Did you specifically raise below the stepfather issue, the fact that he's not a parent? I know I'm not saying you didn't raise parents can't do this. Did you raise the fact that he's not a parent?
Numerous times, Your Honor, numerous times. We even filed a motion that argued because he was a step parent, he lacked standing. And if you'd like, I can get you the cite for that. But we argued it at the conclusion of the evidence. The motion was filed at the conclusion of the evidence. We're not raising that as a separate issue on appeal, but it's pretty clear that he took every opportunity to use that legal misrepresentation while he was testifying.
Okay, but you conceding you've waived that issue on appeal?
We have waived that as a separate issue on appeal, yes, Your Honor.
What do you mean waived it as a separate issue?
Well, it's still relevant to this issue, to the extent his testimony about being responsible, his statement about the law was just not correct.
But the fact that he was acting as a parent, and irrespective of whether a parent can do that, challenging whether he's a parent, you've waived that issue?
Yes, yes. So it's perfectly clear that the real party in interest here was GL. This was all about GL. The special verdict form that was used asked only about damages for GL, and that was a verdict form submitted by Byrd. Didn't ask for any damages on behalf of Mr. Byrd. Now, appellees will get up and say, yeah, but the final judgment awards all the damages to Byrd. Well, we didn't draft the final judgment. The verdict form clearly did not refer to any damages for Mr. Byrd. The trial court repeatedly, in its initial instructions to the jury and in its closing instructions, referred to GL as the plaintiff. Everyone understood that GL was the real plaintiff in this case, and so under the clear language of Rule 4-3.7a, Mr. Byrd was unable to testify on contested matters on behalf of GL, and that's precisely what he did.
So, Mr. Webster, am I correct that you believe that because he was a witness, he should have been disqualified under the rule? But I take it you would not have any issue with Mr. Byrd's being trial counsel if he was not a witness?
Oh, absolutely not, Your Honor.
Let me ask you this. Suppose we reverse on this point, and Mr. Byrd elects to go forward as trial counsel, and takes himself off of his witness list. Could you force the issue by putting him on your witness list?
I think the law, in my recollection, is there's one of the cases the police cited, I think it's the In re Waltrop. It's a bankruptcy case in the Western District of Oklahoma. Seems to indicate that the law is the opposing party can't do that for obvious reasons. So I think the answer is no.
Really? I mean, so if there was some crucial witness in a case, you could remove them as a witness by hiring them as your attorney, assuming they're a licensed attorney?
I'm sorry.
Doesn't that mean in any case, if there was an attorney who happened to be a crucial witness that was bad for you, you don't want them to testify?
Well,
You could stop them from testifying just by hiring them as your trial counsel?
Your Honor, frankly, I've not researched all of the law on that issue. The case that came to mind was this Waltrip case. It says what it says about that issue. That's not our case. That's not this case. And I think I can safely represent to the court that if this matter did go back down for a new trial, we would not employ that tactic.
And let me stick with the rule. I noticed in your motion to disqualify, it included, I believe, striking 8 or 10 video depositions that Mr. Byrd had conducted. In asking us to reverse, are you asking us to also tell the trial court that all of those video depositions must be stricken?
If he was the lawyer conducting the examination, I think that's the logical conclusion, Your Honor. And let me explain to you why I think that's not unfair. Appellees take the position on appeal that we waive this by waiting too long to raise it. The cases they cite relate to attempting to disqualify opposing counsel entirely from a case.
Based on conflict of interest.
Exactly. This is a completely different situation. And we represented, Your Honor's familiar with our motion, we represented in the motion that trial counsel had discussed this with Mr. Byrd at the outset of the case, and that Mr. Byrd said he was going to get counsel to try the case, and that the only reason this motion was being filed was because apparently he'd not done that.
Is there anything in the record that establishes in those representations he said, I'm not going to use the depositions I did?
Well, to the extent he wants to use them at trial, he should have been aware he was going to have a problem under the rule. So Mr. Byrd, we represented in our motion that Mr. Byrd said that at the beginning of the case. On appeal, appellees say, yeah, but there's nothing in the record that supports that representation.
Well, the trial judge, by denying disqualification, essentially left you unable to litigate that particular point. So,
well, and more importantly, Your Honor, Mr. Byrd has not denied that ever in the trial court or in this court.
I want to get back to the depositions, because as I understand the purpose behind the rule, at least reading the comment, is that the reason is a jury can be sort of misled or they might misunderstand a lawyer both answering questions to give evidence and commenting on that evidence as an advocate. Whereas in a deposition, the lawyer is just simply asking the questions. So I'm wondering is the deposition transcript, even if done by video by Mr. Byrd, does it really implicate the concerns of the rule like him answering questions on the witness stand would?
Well, Your Honor, we took that position in the trial court for purposes of this appeal. I'm prepared to say that we won't take issue with those depositions being used at a retrial.
Thank you.
Is there anything to the significance that Mr. Byrd had other trial counsel? Like if a party shows up with 2 lawyers that says, I also want to question witnesses and participate myself, are you pro se if you have lawyers? I don't think any of the cases dealing with whether a party can represent themselves pro se or whether a lawyer can represent themselves pro se, I didn't see any of them where the lawyer was also in fact represented by 2 other lawyers.
I've seen that in criminal cases from time to time, Your Honor. I've certainly never seen it in a civil case. To me, the significance, the fact that Byrd showed up at trial with other lawyers is it's a concession that Rule 4-3.7A4 is inapplicable. That's the one where it says you can go ahead and do this if disqualification would work a substantial hardship. There's no hardship here. They never argued hardship, but there's no hardship because they showed up at trial with lawyers, with other lawyers. And it just shows that, demonstrates, I think, that this was really all kind of a ploy to allow Mr. Byrd to put in all of these long, rambling perorations as a witness, because, you know, these lawyers could have handled the whole case. Or Mr. Byrd could have not testified and handled the whole case. He just chose not to do that.
Given that the trial judge made his ruling based on, you know, what he perceived to be, you know, Mr. Byrd's right to represent himself, if we were to reverse, would Mr. Byrd have the ability to litigate paragraph 4 on remand? In other words, could that still be brought up and sorted out by the trial judge, or are you asking us to say he just can't do it?
Well, I mean, 4-3.7A lists 3 exceptions. The first is, 2 of them relate to the nature of the evidence,
Right.
which clearly are inapplicable here.
Right.
And the third one is hardship. And they demonstrated there's no hardship because they had other lawyers present. So there's nothing to relitigate. This is a simple application of the rule to undisputed facts. That's why, as we argued in our briefing, the standard of review here is de novo. Because but even if it weren't, even if it were abuse of discretion, that discretion scope is cabined by the rule.
Counsel, I want to make sure I ask you about the discovery issue before you leave.
Thank you.
Because there wasn't a lot of talk in the briefs about just the language of the discovery rules. And I'm looking at 1.280, and it says in the subsection D for protective orders that when somebody files a protective order, the trial court can change the terms and conditions of the discovery. The court may order that the discovery may be had only on specified terms and conditions. Why couldn't this discovery procedure be terms and conditions ordered by a trial court?
Well, first of all, Your Honor, there was no motion for protective order under 280 here. This was an objection under 351.
I mean, it's in the subpoena rule too. I mean, it's a 1.410, the trial court may modify the subpoena.
But to answer your question, the reason is because you can't put the fox in charge of the hen house.
But that just seems like a policy argument as to why, like, I mean, this is a term and condition of discovery, is it not? You just say this is a bad idea, but
No, I didn't.
what I'm asking
Well,
for you is why is it not in the scope of the language of the rule?
I mean, it is arguably within the scope of the rule, but the response to that is it's an abuse of discretion. See Rojas
So let
versus
me ask
Ryder
you, I think
Truck.
Rojas was different because in
It
Rojas,
was
the
different.
person was able to control the scope of the request, not just the response, you know, filtering the response. And the reason I'm skeptical of the argument that this is such a crazy procedure is because this is the procedure for all first-party discovery, which is most discovery and litigation. When you serve a discovery request on the other party, they have the documents themselves, and they and their lawyer are necessarily the gatekeeper. That is most discovery and litigation.
And that's precisely the procedure the court in Rojas condemned.
It's not, though. In Rojas, the party was going to be able to go to the third party and request the documents, and so the party not seeking documents in the litigation would have control over the scope of the request, not just the response, right? Here, it was not going to change the scope of your subpoena. It was just, who did the responsive documents go to?
But what the court said in Rojas is allowing a procedure similar to 350, a request for production, won't work here because it relies on the veracity of the responding party.
I guess I'm saying, why is that? All right, taking aside any differences in Rojas, even if you assume that rule is the clear rule of Rojas, why is that the case? Why can you rely on the veracity of the party for the vast majority of discovery and litigation, which is from that party, but it's super dangerous to do that for third-party discovery?
Well, for one thing, if the lawyer for the objecting party is the one deciding what documents to pull out before they get delivered, there's no way to ever know.
How is that different from when you serve a request on the other party? That's what their lawyer does.
Because then, if you're not happy with that, you can use 351 and go to the non-party and get those documents.
No, but I'm talking about for documents that the party themselves has, and maybe a non-party doesn't have, right? Most discovery and litigation is between the two parties, right? And for most of those, it's document that no third parties are involved in. And in those situations, the other party and their lawyer is the gatekeeper by necessity because they have the documents. And we rely on the rules of professional conduct for that, and the discovery rules and the prospect of sanctions for that discovery to occur. I mean, that's the vast majority of discovery is handled under the exact procedure you're saying was an abuse of discretion to order as to third-party
Okay,
discovery.
so in addition here, the gatekeeper was an adverse party in the litigation. That's one thing. And in addition to that, this court has already noted that criticisms regarding Mr. Byrd's professionalism are significant. And so there's no way for us to know whether we're getting a fair deal or not.
In first-party discovery, right, the other party controls the documents when you request documents from the other party, and they're an adverse party in that situation too, so that's not a distinction. And so is the argument, as to the second point, is the argument here that the trial judge should have kind of taken judicial notice of prior past conduct and said, as to this specific lawyer, this procedure is not permissible?
The principal argument here, Your Honor, is there is no way to ensure, other than relying on the good faith of the opposing lawyer, that we're going to get all the documents we're supposed to get. And as Judge Smith pointed out in his concurring opinion earlier in this court, because of that, you can't do that unless the two parties agree to it. It's just not an acceptable procedure.
Counsel, that's my last question. So you have this fear that you're relying on the other party's veracity. How is that same fear not present when you have to get documents from the other party directly, documents that only they possess, which is most of discovery and litigation?
Because you have lots of other tools to double check to make sure you're actually getting all the documents from the opposing party.
What tools do you have in that circumstance that you don't have in the third party circumstance?
You have requests for admissions, you have depositions, you have...
You can take depositions of third parties, right?
Well, you can, but the whole purpose for 351 is to avoid having to do that just to get documents. So this procedure essentially defeats the whole purpose of 351. And Mr. Byrd, you saw from his objection, he does this in virtually every case. There were at least 6 or 8 orders from other trial judges in the Ninth Judicial Circuit where he requested the same procedure. He does it in virtually every case.
Well, into your rebuttal time, we'll give you a couple minutes
Thank
for
you.
actual rebuttal. Thank you.
Very small for that, a very big amount of stuff.
Good luck.
May it please the court, Megan P. Gluka on behalf of the appellees, Jeff Byrd. Would you like me to start in any specific place?
Well, given, we're going to use a lot of the time, maybe we'll just jump right into it. The disqualification issue, the trial court ruled that denied disqualification, cites the Baker case, essentially says that Mr. Byrd had the right to represent himself in both capacities, individually and as the parent or next friend of Gigi, or GL, excuse me. The right to represent oneself derives from the Florida Constitution's right to access to courts. And I find ancient authority sort of endorsing this practice of a parent acting as next friend for a minor child. But I don't find in any Florida case law is any authority that says that that right to represent oneself includes a right to represent, for a non-attorney parent to represent a minor child. And in the absence of that right, it seems like the minor child can only be represented in court by a lawyer. And if that's true, then 4-3.7 must apply. Is my analysis wrong somewhere?
So, Your Honor, Rule 17 is a federal rule. It has a rough equivalent in Florida State Court, but if you look at that 11th Circuit case, the reason that they said that that parent couldn't represent is because Rule 17 lists 4 people who can represent a child: a committee, a conservator, a like fiduciary, or a general guardian. So in this case, Mr. Byrd was acting for himself. And by the way, I want to clarify something that Mr. Webster said. The defense's motion to disqualify at paragraph 3 says plaintiff Jeffrey Byrd is claiming his own damages. So there is no question that Mr. Byrd was claiming damages for himself. The defense acknowledged it in their motion, and the business about the verdict form, it's so that the verdict form didn't say, what are the past expenses or what are the medical expenses for Gigi Luhia's future care that go to Jeff Byrd until she reaches the age of 18, and then after the age of 18, when she becomes an adult, what future care? Like, that would have made the verdict form silly, which is why it didn't say it that way. But there's no question that he was seeking his own damages. I want to put that to bed. And second, Mr. Byrd was acting as, excuse me, he was acting as the guardian for his minor child, number one. And number two, he is a lawyer, so he can represent her.
Well, but I think that's the issue. There's no question that Mr. Byrd could represent his minor child in litigation as a member of the Florida Bar. He's authorized to practice law. But that really gets to the heart of the question, because if the trial judge said basically 4-3.7 doesn't apply here because he's representing himself, he's self-represented, that's a right that he has. But I don't find that right in any Florida authority. In fact, 1937, there's a case, it is Garner v. Schilling, and it assumes that just because a next friend, it uses this old French term, prochain ami, just because a next friend can bring a lawsuit on behalf of a minor, that doesn't mean that that next friend is authorized to represent the minor in court proceedings. That still requires a member of the bar. Now here, I don't think the issue is whether Mr. Byrd could represent his minor daughter as an attorney, but as an attorney, he's then subject to all of the rules, including 4-3.7. I don't see how the trial court could get around that by saying, well, he's got a right to represent himself.
So, Your Honor, there is no Florida court case that is directly on point. No Florida court case has analyzed it. However, the answer brief pointed to a plethora of out-of-state cases that have analyzed it. And the out-of-state cases, their rules are, if not verbatim duplicates of Florida's, they are extraordinarily close because they're all based on the ABA's model rules.
Well, as I read the answer brief, that's only dealing with cases talking about an attorney's ability to represent his or herself. But you only put in a footnote the issue of whether that attorney can represent a minor child and whether the rule doesn't apply in that situation. So I don't think that this issue has really been addressed by any of the cases you cite in your brief.
Well, Your Honor, I guess my hang-up is that there's no question that Jeff Byrd is an attorney, and there is no question that Jeff Byrd could represent his minor child because he is acting as her guardian. There is no,
well,
so
I
in other
don't
words,
think that's not a represent. When the lawsuit is filed by a parent as guardian or as next friend of a minor child, that's a standing convention. I mean, there's no doubt the lawyer has the right to bring that lawsuit, or a parent has a right to bring that lawsuit in the child's name. It's a separate question whether that parent can also represent the child in court, which usually requires a member of the Florida bar. And the case law says, well, you can represent yourself, both criminally and in civil cases, not being a member of the bar. That's a constitutional right in Florida. But there's no constitutional right for a non-lawyer to represent a child. And that means that every time Mr. Byrd appeared in court on behalf of GL, he was appearing as a lawyer, which means all of the rules applicable to lawyers must apply. And as I read 4-3.7, he can't be both the trial counsel and a witness. I don't see any way around that, just by saying, well, he had a right to represent himself.
Well, Your Honor, the first argument that I would make in response to that, because I think I understand where you're going now, is that the defendant never raised that argument. So it's not an argument that this court should consider because it was never raised and it wasn't properly developed below. And the trial court wasn't given the opportunity to consider that argument. And this court, as longstanding Florida law says, doesn't consider issues that were not raised below. That's the first point that I would make. And the second point that I would make is that the case law that is cited in the answer brief goes to the purpose of the rule, because disqualification is an immensely unusual remedy that should be used sparingly. The law in Florida is very clear about that point. And the cases that we gave you said that the purpose behind the disqualification rule is to prevent situation in which others might think the lawyer, as witness, is distorting the truth for his client, or is enhancing his own credibility as an advocate by virtue of having taken an oath as witness, as well as the uneasy situation that arises when opposing counsel must impeach on cross-examination another lawyer adversary. And the 10th Circuit Court of Appeals has said to apply that rule when the testifying advocate is a litigant in the action miscomprehends the thrust of the rule. The equivalent of 4-3.7 regulates lawyers who would serve as counsel and a witness for a party litigant.
In this case, that would be GL. GL is the party litigant.
Correct. And
Mr. Byrd was serving both as counsel and as a witness for GL.
correct. And my point is that these arguments, so the court says that that rule does not address the situation in which the lawyer is a party litigant, and any perception by the public or determination by a jury that a lawyer litigant has twisted the truth surely would be due to his role as a litigant and not, we hope, as his occupation as a lawyer. A party litigant, moreover, as a party litigant, a lawyer could represent himself if he so choose. We can see no reason why the right to self-representation should be curtailed, especially in light of the non-existent concerns over credibility and impeachability, prejudicing a third party. Because in that circumstance, when Mr. Byrd is on the stand and Mr. Byrd is standing at the podium, and by the way, we've cited to the record, he was very careful to tell the jury, I'm playing two different roles here, and when I'm standing here behind the podium, what I say is not evidence. It's only when I take the stand that what I say is evidence. And I would also point out that during the entire trial, 1,972 pages, I believe, of transcript, the defense can only point to 2 places where the defense counsel was bothered enough to even object. He didn't ask for a curative, and he didn't ask for a mistrial. So if there was an error, you also have to find that it was harmful. And here, Mr. Byrd went out of his way to make the statement that I am playing 2 different roles. And the jury could see that. And that is what all of these cases that we cited to you, Ohio, the 11th Circuit of Appeals, the 8th Circuit, the 10th Circuit, Pennsylvania, Virginia, they all say the same thing, which is lawyers or juries aren't stupid. They can see that when the lawyer is standing up there and he's representing himself and his daughter, and it's clear that he is her father and he's testifying on the stand by that, they know what's going on. And if they think he's warping the truth, then they're going to think that because he is acting as a father and an advocate and not because it's a disinterested client.
If that's true, why does the rule speak in mandatory terms, shall not be trial counsel and a witness, and doesn't say, but you can fix it with a curative instruction to the jury? In other words, the rule doesn't contemplate that this problem can be solved simply by telling the jury, keep in mind that he's wearing 2 hats here.
Well, Your Honor, I would say that that would be at odds with the absolutely unequivocal uniform case law of this state that disqualification is an immensely unusual remedy and that it should be used sparingly. I would also point out, as we did in the brief, that the defense didn't take the opportunity to take this up on certiorari. If they were actually concerned about it, why did they not do that? And there is precedent for the idea that if you wait until after, if you wait to take a plenary appeal on an issue like this, that they are now arguing is so incredibly fundamental, that the judges, that this court should look on it with suspicion. And I also would note that Mr. Webster told you that the standard of review here is de novo. That is dead wrong. The reply brief cites a Florida Supreme Court case, Young v. Achenbach, 136 Southern 3rd 575. The reply brief cites that case for the idea that the standard of review is de novo. It perplexes me because the Florida Supreme Court said at pages 580 to 81, in this case, the third district's review should have been limited to whether the trial court abused its discretion in granting the disqualification motion. And then they quote from the fourth DCA, the standard of review for orders entered on motions to disqualify counsel is that of an abuse of discretion. So here you would have to find that the trial court abused its discretion and that there was harm.
But don't we also have to look at any underlying legal standards and decide those de novo on the way to deciding whether there was an abuse of discretion?
Well,
And the trial
Your
court
Honor,
can't make a legal error and say, I have discretion to do that.
the trial court's discretion is limited by the applicable legal principles. However, those principles are based on policy considerations. So again, disqualification is an extreme remedy, and the policy considerations behind the lawyer-witness rule is that if I am representing a corporation and then I go take the stand on behalf of that corporation, the jury could be potentially confused. It could be
Counsel,
unclear to them.
The Supreme Court may take into account policy when it decides to write rules. Once the rules are written, we're not the writer of the rules, and we don't consider we're not policy judgments on that in that place. For us, we just have this word that says shall, and whatever policy judgments, the writer of those words may have taken into account led them to use certain words. And I agree with you that disqualification is a rare remedy, but this is one of the places where the rules say shall. Whatever policy judgments they made, they then use that policy judgment to give lower courts an instruction of shall, didn't they?
Your Honor, it is first of all, I see this all of the time. It is courts that are terrified to move beyond a strict construction. And it does say shall, Your Honor, the rule does. However, there is a body of law. There is no case law in Florida, number one, and the only case law that was cited by the defense is the Springtree case. And even in that case, the fourth DCA didn't say that the lawyer who was representing himself and his wife did violate 4-3.7. The court said that it could. The only reason that they disqualified there is because they said the word, it was obvious. It was obvious that that lawyer could not sue Springtree, the shopping center, because that was his law firm's former client.
I actually agree with you about the strict construction concept. I don't know that that's a very useful concept in a lot of cases, but you don't have to very strictly construe the word shall to take it as mandatory, right? That's kind of obvious and plain meaning. Strictly, I mean, that's just obviously mandatory language, is it not?
Well, Your Honor.
Like, that's not really ambiguous language that we're strictly construing. Shall is kind of shall.
Well, again, I go back to, you look at the shall in the context of when that rule is, the circumstances under which the rule is being applied, because there is an as-applied challenge here, which is...
But it gives certain circumstances where you are it carves out from the shall, doesn't it? I mean, it says shall except 1, 2, 3, not shall except when it otherwise makes sense.
Your Honor, all I can say to you is that we cited to you a wealth of out-of-state cases that have decided the issue, and the wealth of out-of-state cases say that under circumstances like this, that it's not a disinterested lawyer who is testifying on behalf of their corporate client where a jury could be confused. This is a man who's bringing his own claims and bringing claims on behalf of his child. It is painfully obvious to the jury that if he was going to twist the truth, because that's the purpose behind the rule, if he's going to twist the truth, he's going to twist it for his own reasons, and the jury can see that, and it shouldn't apply. And finally, because my time is dwindling, I do want to bring up the timing here. Your Honors, the defense put Jeff Byrd on their own witness list on November 4th, 2002.
I totally get your point about the delay. And, you know, they say that this was just a disqualification for trial and not for the whole litigation.
Their motion does not say that.
I guess if you assume that's true, right, I'll just ask you to assume first this question. How far in advance, because I think it's an interesting question, right? Because even if it's just for trial, if you do it the night before trial, I think you've delayed, right? If you do it 8 months before trial, less so. Assuming you're just trying to disqualify a lawyer just for trial, how far in advance do you need to do it?
Well, the law says that you look for reasonable promptness. Reasonable obviously has room. It's going to be a discretionary call. However, in this case, in their own motion, they listed the 9 depositions that Jeff Byrd had taken. Obviously, Jeff Byrd took them. When the complaint was filed in October 2001, Jeff Byrd's name was the only one on the case style.
Don't they represent in the motion as well, though, that there was a representation by Mr. Byrd that he wouldn't act as trial counsel, which seems like that would forgive them not saying anything while he was taking depositions or even up to 45 days before trial. By just simply denying the motion, I don't think the trial court gave the parties a chance to litigate that representation to decide whether it was made or not. Doesn't that matter here?
Your Honor, I think what matters a little bit more is the procedural history, and here's why. They waited until after their motion to continue had been denied. And then they waited until after their case didn't settle at mediation. And then they waited until after their expert was stricken. And then they waited until after that motion to disqualify the expert was stricken. And at that point in time, under the rules that were in place, if you could get your trial continued, you would have more time, which meant more time to find another expert. And so, Your Honor, I think it's very important to look at the procedural history, because if Mr. Byrd had been disqualified, then that meant this case wouldn't have gone to trial in 45 days. It would have been continued again. It was, I heard Mr. Webster use the word ploy several times, and while I don't like to go there, I think that the procedural history is important and the waiting is important, because it was very obvious that Mr. Byrd was going to be a witness, and what they said was a very vague, we've talked to him before. And Your Honors, if you're going to file a motion 45 days before, then you say, I talked to Jeff Byrd 6 months ago about this, or I talked to Jeff Byrd 3 months ago about this, or whatever it was. But the point is that on November 4th, 2022, they knew if it was important to them.
Did you say anything in your response of, hey, that conversation just happened 2 weeks ago? I mean, was there any contesting of their position that they had reason to believe Mr. Byrd was going to get separate trial counsel?
Your Honor, I do not think that anybody developed that in the record at all.
I mean, I take your point about the specificity, but they made the point, and you didn't contest it, did you?
I do not have the record memorized. I had more time. I've only got 58 seconds. I could look and tell you, but.
Yes, when a parent hires a lawyer, say, so assume a non-attorney parent of a minor, minor has a lawsuit to bring, they're in a car wreck, whatever, and the parent, as the parent hires a lawyer, okay, and the parent is acting for the child and managing the litigation, the lawyer is representing. Is the lawyer representing the parent in that situation or the child?
Are you talking about an instance like if?
And just generally, so, child is injured, whatever, has a reason to sue someone, and obviously, a 6-year-old can't sue. Their parents bring the suit in their name, like you're saying happened here. And I'm just saying, take it, it's a non-attorney parent, and they go hire a lawyer. And the lawyer brings that lawsuit that the child has, but that the parent is bringing on their behalf. Is the lawyer's client in that circumstance the parent or the child?
It would depend on what the claims were. If the parent was trying to recover what the parent had paid for the child's medical bills, then the lawyer would be representing both the parent, because a 6-year-old isn't legally responsible for their medical bills, and the child for the child's non-economic
But as to the
damages.
child, I take your point, it could be both, and the lawyer could have two clients. But as to the child's pain and suffering, is the lawyer representing the parent or the child? Who's the client?
In a legal context, it has to be the parent, because Rule 17 in the federal rules and Rule 1.210 in the state rules say that a child can't represent themselves, they have to be represented by someone else. So similar to a wrongful death situation, the attorney represents the estate. There are members of the estate, but the attorney represents the state and the estate. And here, if a lawyer was hired to represent a parent who wanted to bring a lawsuit on behalf of their child, and that parent also wanted to recover the money that they had paid for the medical bills, the
That's a good
parent
example,
would
though.
be,
The personal representative in that situation directs the attorney, because the personal representative acts on behalf of the estate, but the lawyer's client is the estate, right? That's the real party in interest?
well, the personal representative is the client.
Yeah, as a personal representative of the estate.
Well, in this case, though, to Judge Gannam's point, the child cannot represent themselves. The child has to be represented by a guardian, and the client is the guardian. The child isn't telling the lawyer what to do. The guardian is the one who's
Yeah,
making
the
the
guardian's
decisions.
doing that for the child. I guess I'm just saying, is that because the guardian is the client, or because the child is the client and the guardian is acting as on their behalf as guardian and directing their attorney?
The guardian, Judge Gannam, it's all clicked together for me. I think in response to your question, under the law in Florida, Gigi Lahia could not have represented herself. She needed Jeff Bird to bring that lawsuit. Jeff Bird represented himself for his own damages for what he paid for her medical bills, and Jeff Bird represented himself because he was acting as her guardian. We don't let 12-year-olds decide what they're doing.
So that's based on the idea that when a parent hires an attorney for the child to bring claims on behalf of the child, in order for your argument to work, the client in that situation must be the parent/guardian, not the child.
Correct, the client is the guardian. And
If a parent is acting for a child, say that same situation, but the parent's a non-attorney, parent doesn't want to hire an attorney, can a parent, assume there's just claims only on behalf of the child, right? There's nothing but the child has claims, pain and suffering, that's it. It's only the child's claims, parent has no claims. But the parent is the guardian of the child, and the child needs to bring the suit. Can the parent represent the child in court?
can the parent represent themselves? Because again, it
Yeah,
is a legal, it's
I'm not
the
trying to,
legal
I'm not trying
setup
to get,
that
I'm not trying to
we,
get bogged down in the semantics. Can that parent walk into court and pursue that child's claims without an attorney?
a parent acting as a guardian on behalf of their child to bring a legal claim could proceed pro se in Florida state court because they're acting, their legal capacity is as the guardian for the child, because we don't allow 12-year-olds to bring lawsuits. We don't allow 12-year-olds to tell lawyers what to do. So I believe that Mr. Bird was acting pro se for his own claims and for the claims because Gigi Lahia could not bring that lawsuit. He was acting as her guardian. And if the only claims that Gigi Lahia had were non-economic and he wanted to go hire a lawyer, Jeff Bird wanted to go hire a friend to represent him in that case, they would be representing him. They would be representing Jeff Bird as guardian for Gigi Lahia. And I know that I'm over my time, but could I just indulge me for 30 seconds regarding the records?
30 seconds.
Thank you. So it's an abuse of discretion to standard. Everyone agrees. And the record has 42 pages of other orders because in that circuit, it is common practice. And those orders are at 144 to 186. It is common practice for judges to do this procedure. One of the orders that he included, this same judge issued this same procedure against the same defense lawyer. That defense lawyer took it up on cert to the 5th DCA. I handled the appeal, and the 5th DCA denied cert. So this trial judge knew that this procedure had not
Denial
been...
of cert's discretionary by an appellate court, though, right?
Correct, Your Honor, but my point is, how is a trial judge supposed to believe that he would be abusing his discretion? Because Canacaris v. Canacaris, the Florida Supreme Court says that an abuse of discretion can only be found.
Counsel, isn't the more on-point argument that the rules say trial judges can modify the terms of discovery?
Yes, Your Honor, and I mean, even the
Okay, you're well
Rojas-
past your time. Can you please wrap up?
Yes, even the Rojas case, the Florida Supreme Court says that, to your point, Judge Mize, the rules governing discovery are not exhaustive and do not prohibit judges from using their discretion to fashion an appropriate remedy.
Thank you, counsel. It's saying 2:13 on it, so we will go with that. Charlie, did I mess this up? Okay, so we're gonna go with you having 2 minutes and 13 seconds.
We probably will let you stop in a minute, so.
I'm happy to stay as long as you want me to.
Oh, this was 2 minutes and 15 minutes over, so, okay, so we'll give you until it says 5 minutes.
I want to first correct some misstatements that I'm sure were inadvertent by opposing counsel. The motion that was filed was titled Defendant's Motion to Disqualify Plaintiff Jeffrey Byrd as Trial Counsel for Plaintiff Giselle Elijah. Secondly, in that motion, it says defense counsel has conferred with plaintiff's counsel about this subject long ago, and plaintiff's counsel represented that he would find another lawyer to try the case, but plaintiff Byrd has not done so to our knowledge, therefore this motion is filed. They have never attempted to refute that. Second, with regard to certiorari, we heard that both with regard to the discovery motion and with regard to the disqualification. Certiorari wouldn't be available in either situation because there's no irreparable injury. What happened in the prior case in the 5th DCA that counsel represented she handled, it wasn't denied, it was dismissed. And I suggest to you the likely reason was because there was no irreparable injury that couldn't be remedied on appeal pending entry of a final judgment. The same would have been true here if we'd have tried to take a cert petition from the order denying the motion to disqualify Mr. Byrd as trial counsel. Third, counsel referred to a wealth of out-of-state cases cited in her brief. In fact, there are 3 cases cited. Brooks, Angino, and Waldrop. 2 are trial court cases, and the third is a South Carolina case where the court actually held that the lawyer's wife could not represent him because of Rule 4-3.7a. Those are the only cases they cite. That's the wealth of cases. With regard to, let me just go finally, with regard to Rule 4-3.7a, it could not, Your Honors, be clearer. It says a lawyer shall not act as a lawyer if he is to offer material conflicted evidence at trial unless, and then it lists free.
Counsel, can I ask you to address before you go the 2
Sure.
questions that I asked your opposing counsel? When a parent hires a lawyer to represent their child has claims, child can't bring their own lawsuit, parent's not an attorney, parent hires a lawyer to bring the child's claims. Is the attorney's client the parent or the child?
I would say arguably both, but the real party in interest is the child. You can't read this transcript and conclude anything but that the only real party in interest in this case was the child. Mr. Byrd's verdict form doesn't even ask for a damage award on his behalf. Thank you, Your Honors.
Thank you. We will be in recess.